So you worked hard to build your brand and you filed your US trademark application. Your business is growing and you're starting to sell overseas or through global platforms like Amazon or Shopify. But here's the problem. Most founders make at least one of four international trademark mistakes, and every single one of them can cost you your brand, your customers, and your peace of mind. So today, I'm going to walk through each of these mistakes, what actually happens when you make them, and how to prevent them before it's too late. So the first and most common mistake is waiting until after you go global to file your trademarks internationally. Here's why that's dangerous. In the US, trademark rights are based on using your mark. Whoever uses the mark first in commerce generally has what are called priority or senior rights. But in other countries, it's first to file, meaning whoever files the trademark application first owns it, period. If you launch a product internationally and then think about protecting your name, someone in that country can file your brand before you and they'll legally own it there. So you got to do more than think. This means if they own it there and you don't, you may have to pay them to get it back. They could block you and your imports from coming into the country. They can even take over your listings on your website. Or worse, they could sell counterfeit goods under your name in that country, which is a very, very common situation. So if you plan to expand or even might, you need to file early through what is called the Madrid Protocol. The Madrid Treaty is a treaty between 125 plus countries to make it easier to apply for trademark rights in all of those member states, as they call them, states or countries. It's far better to protect your rights proactively than to try to reclaim them later. If you missed my earlier video on how to get your international trademarks, go back and watch it. I explain exactly how the Madrid system can save you thousands on legal costs. But let's go to the second big mistake. Not having written IP agreements with your foreign manufacturers and distributors. This is a really big problem. Here's the harsh truth. If you don't have a contract that clearly states that you own your trademarks, logos, packaging designs, etc., then your manufacturer might claim ownership and they can register your brand name in that country before you even know it. And this happens a lot in China, Vietnam, India, and even parts of Europe. And those manufacturers can then hold your trademark hostage, refuse to release your products, or demand money to transfer the registration back to you. This is a really common problem. I have a client that was manufacturing skincare in China, and they ended up having somebody, and we think it was someone from the manufacturing facility, go to register their brand name, not just the name, but their exact logo in China, setting up for this type of standoff where my client would have to pay them for the rights to use that name and to basically get their products back. And I have partnerships with counsel in these various countries, and I contacted the law firm that I have contacts with in China, and we had to take very aggressive legal action in China and file an opposition to the registration of those trademarks to prevent that manufacturer from getting my client's registration. And then we had to file for registration for my client, both for their brand name and their logo. And that obviously it's been a very expensive process. And so I want to make sure that you aren't in that position, because that is something that happens all the time in China. And often the US-based brand owner doesn't know it's happened until it's too late. Thankfully, my client and I did learn of this before it happened, and so we were able to get in front of it and hopefully prevent it. Here's one bit of advice is make sure that you always have what are called work for hire plus IP ownership clauses in your manufacturing agreement. So your contract should always include a clause. We call it work for hire under the US Copyright Act. But it basically says that anyone working on your behalf that is a contractor or a vendor, like a manufacturer, is assigning all of the rights, all of the legal rights, and anything they create for you to you. Second, you want to have a clause specific to trademark and branding ownership that clearly transfers all IP rights to you and makes it clear that you own your brand name and all of your IP in that country. And third, and this is incredibly important, a non-registration clause stating that they cannot register your marks or any similar ones anywhere, so that if they attempt to do it, it's a breach of contract. Now, please have those drafted by an experienced IP attorney like me. The wrong clause or signing them in the wrong order can actually void your protections. Now, if you want to understand how this works under US law, you can watch my earlier video on work for hire agreements. It explains why ownership isn't automatic, and even when you paid for the work. And this applies to copyrights, not just trademarks. Okay, let's jump to the third mistake. The third mistake is assuming that your US mark protects you elsewhere. This one's short but critical. A US trademark only protects you in the US. That's it. If you sell or license your products in other countries without registering here, you are completely exposed. Even Amazon sellers often learn this the hard way. In fact, it's a pretty chronic problem on Amazon. They think that their US registration covers their international Amazon listings, but it does not. US rights stop at the border. So if you want global protection, you have to file proactively globally, either through the Madrid Protocol or directly in the countries that you operate in. And that's something I can assist you with. The Madrid Protocol, I've done a whole video on. It makes it a lot easier and a lot less expensive, but we can do it either way. And there are sometimes strategic reasons why you might file directly in the companies that you're operating in instead of using the Madrid Protocol. This is just really important to be proactive on this. And then mistake number 4 is ignoring translation and localization issues. This is one I've talked about briefly before, but your brand name may sound great in English, but what does it mean in another language? There are many famous companies that have learned this lesson the hard way. When Coca-Cola first entered China, the original translation meant bite the wax tadpole. And Pepsi's slogan once translated to brings your ancestors back from the dead. So before expanding globally, check how your brand name, slogan, or logo translates in the markets that you're targeting. It's not just about meaning, it's about sound, symbolism, and even cultural context. So always vet the translation and cultural meaning. Ideally, you're going to work with a trademark lawyer when you're first branding your company. That's the best time to do it. So you can explore these issues before you choose a name. If you are building a company and you know that you're potentially going to have an international presence, those are the conversations you want to have early on when you're first naming. And as a side note, when you're applying, even in the US, there is a doctrine of what's called Doctrine of Foreign Equivalence, where if you're using a name in another language, you have to translate it into English in order to understand what it means, because the trademark office here in the US will actually do that translation. You have to understand that that's going to happen in other countries as well. And so these are things you need to be thinking about ideally when you were first naming your business and doing the branding. But if you didn't and you're already operating, it's important to do it as soon as possible. So let's recap the 4 biggest international trademark mistakes to avoid. Waiting until after you go to global to protect yourself, not locking down IP rights in your manufacturing agreements, assuming your US trademark protects you worldwide, and ignoring translation and localization issues. If you avoid these, you'll be miles ahead of most business owners, and your brand will be safe, strong, and scalable wherever you go. So if your business is growing internationally, or you're even thinking about it, now's the time to make sure that your brand is secure in every market that matters to you. I help founders build international IP strategies that prevent these mistakes so you can expand with confidence and not fear. So just set up a call with me. I do free consults. We can talk about your specific situation, and we can map out a brand protection strategy country by country. So just give me a call and we'll work it out together. In my next video, we're switching gears. We're going to talk about the new frontier of intellectual property, AI-generated content. Who owns what in your business when you're using AI? Can you copyright or trademark AI-generated works? And what new legal risks are emerging for founders who use AI in their business? We'll unpack all of that and more in my next video. So I'll see you there.